Skip from Malik and Malik. This is another full commission order from the Industrial Commission. These are in us. I mean, you could look at these online. I'll put the link, or I don't know if I can put the link, but I'll show you where you can find these full commission orders. And what full commission means is an employer or the injured worker files a request for reconsideration before the full commission, and then if it's a novel thing or there's clearly something wonky, they might take it up. And so the full commission are these three people representing, I think one of them's labor, one of them's employer, and I forget what the third one is. But nevertheless, it's going to be three of these folks. They're appointed to that position by the governor, and then they're the commission. So this is this particular decision relates to a light duty job offer. And so I've talked about light duty job offers in the past in the context of what is a good faith light duty job offer. And I might link to that prior video here so you can read about that. As far as good faith light duty job offers, the state of Ohio really hasn't defined what's good faith or what that would mean. With these light duty job offers, they don't really necessarily have to be something that's fulfilling or compelling or something that isn't, even demeaning in some instances. They could literally, as long as it adheres to the restrictions, they could stick you in a room and then, have you, I don't know, look at the wall all day. I mean, it'd be bizarre, but theoretically they could do that. And we recently had an injured worker. I don't think this was horrible. I thought it was kind of interesting, but they had this injured worker going into this charity place, and they were like creating greeting cards. So I don't know. I guess they would sell these greeting cards for charity, and then raise money for whatever this organization is. So his employer sent him there to make greeting cards. Frankly, maybe that's not a horrible thing. I don't know if I might actually enjoy that, making greeting cards all day, but nevertheless, it's kind of weird. But the point is, that would be a legitimate light duty job offer, even as bizarre as that sounds. What they can do, or what that case that I previously talked about, is the employer can't offer you something that they know you can't do. That wouldn't be a good faith. So if they know that you can't work first shift because, for instance, you're taking care of kids, then they can't say, hey, the light duty job offer is first shift. So an important thing about a light duty job offer is it has to be communicated. So they usually say written light duty job offer, and you think, okay, that's in a writing, but that could be like email, could be text, and they say light duty, it's written. The idea is it's that you've received it. I mean, theoretically, if you're given a verbal light duty job offer, theoretically, if they could prove that you received it, I don't know, they were recording the communication of the light duty job offer to you. They might be able to argue you received it, but regardless, the hard rule is it has to be a written light duty job offer. Either it's in a correspondence that's mailed to you, or it's emailed to you, and then you receive it. And then if it's commensurate with the work restrictions that you have, then you have to do that light duty. If you reject it, then you are forfeiting temporary total disability. You're not entitled to it, even though you're not working ostensibly due to your work injury. So this full commission decision was the SHO granted temporary total on this, and the idea was the injured worker did not reject the light duty job offer within his restrictions, and they granted comp. And so the employer appealed, and then the full commission determined that the injured worker had refused a good faith light duty job offer. And so at the SHO, apparently the injured worker testified that he refused a verbal light duty job offer to discuss with the doctor. And again, remember, it has to be in writing. And the employer at the SHO claimed, hey, we emailed it to this guy. And the injured worker alleged that he didn't receive the email, the light duty job offer from the employer. And at the SHO, apparently he said he didn't receive it, but he had talked about the restrictions with his physician, and his physician he claimed at the SHO that his physician had received the restrictions somehow. And so there was no evidence that the physician was copied on the email or had received a copy of the light duty job offer. So the implication was that the injured worker had, in fact, the inference being that the injured worker had, in fact, received the light duty job offer, had conveyed that written light duty job offer to the physician, talked with him, um, and then had this conversation with the physician. And so what that proves is that he actually received it, and that it was within the commission found that the restrictions that he had were commensurate with the light duty job offer, or the light duty job offer was commensurate with the restrictions. It fell within the restrictions of his given to him by his BWC doctor, and he rejected it by not taking it. And then apparently it was confirmed by the commission that he had received that was in fact his email, was the email that the light duty job offer was sent to, and it was transmitted to the proper address. So, and they found the injured statement that he did not receive the offer was not credible, because you have to receive the offer. If you don't receive the offer, that's an argument or a defense against, it's basically saying, hey, I never got the offer, therefore you should continue paying me temporary total disability. So the employer might say, hey, we sent him this light duty job offer, and then the injured worker might say, I never received it. And if the employer can't prove that they actually sent it and that the injured worker received it, then the industrial commission might say, hey, they never got it, so it was never conveyed to them, so they didn't have to take it. So therefore you have to keep on paying them comp, or pay them comp over the time that they're requesting. So in this case, they kind of sussed out this guy, and they said, hey, you actually got it. And we don't find your accounting that you didn't get it is not credible. Therefore, they said he's not entitled to temporary total disability compensation. And the bigger point in this is with hearing officers and this full commission. I mean, these hearing officers do thousands of these hearings a year. And in this case, this staff hearing officer did find the injured worker credible. It was the commission that didn't find him. But the point being is, you're not going to be able to get one over either on the hearing officers or these commissioners. So always be 1,000% honest when you're testifying at hearings, or you're talking to your doctors or anybody. You don't want to be dishonest in any capacity when it comes to your workers' comp claim. It's not a good idea. So, so that's an interesting decision. But yeah, you have to, if you receive the light duty job offer and it's commensurate with your restrictions, then you got to attempt that light duty job offer. So then the next question is, what happens when you go to the light duty job offer that's allegedly consistent with your restrictions that you have? What happens when you go there and you can't do it? Like you give the good college try, and apparently the 20-pound limit is too much. You really need like a 15-pound lifting limit or a 10-pound limit, or you need like sedentary restrictions because being on your feet with your knee injury is too much. In that case, you need to call your BWC doctor, and you need to get your BWC doctor involved, and you need to have your BWC doctor communicate to your employer, hey, he can't do this. I'm going to adapt the restrictions. I'm going to change the restrictions to be a little bit more stringent. Maybe instead of being able to lift 20 pounds, you can only do 10 pounds. And then, if the employer can accommodate that, they can. If they cannot, then again, they would have to pay you, or the argument would be they'd have to pay you temporary total disability. But you have to do that, thing. You have to get your BWC doctor involved. You can't just unilaterally say, I can't do this, because you're not a medical professional. And if you do that, you're going to forfeit, comp, and or you might end up getting fired. So anyways, this is light duty written job offer. Whether or not this person was communicated to this person. Again, the commission found that it was communicated to this person. It was emailed to him, and they found he was not entitled to comp. So workers' comp claims in Ohio, very complicated. There's another one. Always reach out, look in Google, research work injury attorneys or whatever. Ask your coworkers and get a reference to a workers' comp attorney. But call a workers' comp attorney, run by your situation with them, because it's these workers' comp claims are too complicated to do on your own. So, anyways, this has been Kip from Malik and Malik. Thanks for watching, listening, and hopefully you found something useful in this video. Thank you. Bye.